In this video part 2, this yesterday I posted Companies Act revision video part 1, that is for dividends, books of accounts and auditors. Now we'll see revision video part 2. We'll be seeing director's chapter now. So in the director's chapter, section 149 talks about minimum and maximum number of directors. So, 1% company, private limited company, public limited company, minimum 1, 2 and 3 and maximum is 15. If you want to increase beyond 15, then you have to pass special resolution, and amendment of article is also necessary. For section 8 company and government company, this increase of more than 15 can be done even without passing special resolution. Then 149 subsection 1 proviso is there, which is woman director. Every company which is a listed company or public company having paid up capital of 100 crores or more, or paid up capital 100 crores and turnover 300 crores or more, they have to appoint one woman director. And if there is a vacancy, it should be filled within 3 months or next board meeting, whichever is later. And 149 subsection 3 says resident director. A person should be, at least one person should be a resident in case of all the companies. So every company they should have at least one resident director. Then 149.4, in case of listed company or in case of public company having paid up capital 10 crores or more, turnover 100 crores or more, loans, borrowing, deposit, deposit exceeding 50 crores, they should have at least independent directors. So in case of a listed company it should be 1/3, and in case of public company it should be in case of listed company it's 1/3, in case of public company it's only 2. Okay. And if there is a vacancy, if they are satisfying the minimum levels, that is even after resignation of independent director, this 1/3 or the 2 condition is satisfied, it is not necessary to appoint some other person as independent director. Independent director tenure is for a period of 5 years. They can be appointed for a period of 5 years, and they can be reappointed for a period of another 5 years. But for reappointment, they should pass special resolution and justification report should be there. Then independent director should be having expertise in the field of accounts, finance, marketing, sales, administration, and independent director should not be having a relationship with promoters, key managerial persons. Independent directors should not be auditors. Independent director should not be an employee who retired in last 3 years. Independent director should not hold shares more than 2%. Then independent director should not be from the council of legal firms which is having received more than 10% of their turnover from this company. Then independent director should not be a CEO of a non-profit organization which receives 25% of their receipts from this company and their promoters, directors. So these are the disqualification for the independent director. And you cannot appoint independent director more than 2 terms of period without a cooling period of 3 years. So it is not necessary that independent director shall be appointed for a period of 5 years. They can be appointed for even say 3 years or 4 years, and they can be reappointed for say 3 years or 4 years or 5 years, but they cannot be reappointed after the 2 consecutive terms of period without a cooling period of 3 years. Then independent director will not be receiving remuneration other than sitting fees, reimbursement of expenses, or profit linked commission. That profit linked commission is not specified under the section 149, it is specified in section 197. So including the independent director, the overall remuneration should not cross that 11% limit. Then sitting fees, you can pay independent director. Independent director, woman director should not receive sitting fees less than compared to other directors. So it should be equal to or more, it should not be less. Then sitting fees can be maximum of 1 lakh rupees. The independent director will not be liable unless otherwise they gave their consent for the activities. And vacancy of the independent director should be filled within 3 months of the vacancy. Previously it was different, now it got amended, it is just 3 months now. And independent director has to follow schedule 4. Independent director should have separate meetings, etc., which is there in schedule 4. So these are independent directors. Then independent director should not be having pecuniary interest. Pecuniary interest is monetary interest. They should not hold any pecuniary interest in the company. Then we'll go to the next section, 150, a database for the independent directors. Independent directors can be selected by the directors. They can give justification. If the director don't know to appoint independent, they can go for data bank, which is provided by central government under section 150. Then 151, small shareholder director. In case the company is a listed company, it's not mandatory for appointing small shareholder director. In case the company is a listed company, then if 1/10 or 1,000 shareholders, that is the small shareholders, if they give notice in writing to the company's board, then the board of director has to appoint at least one small shareholders director. It is not necessary that small shareholder director should be a small shareholder and all. Then a small shareholder director will be holding office for a period of 3 years. Both independent director as well as small shareholder director or non-rotational directors, because they have fixed tenure. There it is 5 years and here it is 3 years. Small shareholder director should be a person who is having capacity of appointing himself as an independent director. So it is one of the quality of him. Then one person can be maximum SSD in 2 companies, and these 2 companies should not be competing each other. Then section 152, rotation of directors. It is applicable. See, 152 has so many sections, and main section is rotation. So I will start with 152.1. 152.1 is first directors. Every company should have their first directors named in the articles. If the articles fail to mention, then subscriber to the memorandum. If they are individuals, they will become the first director, because section 149.1 says only individual can become director. So subscribers, only if they are individual, they can become director. Then if subscribers are body corporate, then in general meeting they have to appoint director, first director. Then 152.2 says every director shall be appointed in general meeting. So by passing ordinary resolution, you can appoint a director in general meeting. 152.3 says they should have DIN number to become a director. This is what is also mentioned in section 164 also. Unless otherwise you have DIN, you cannot become a director. Here there is an amendment. Central government says that it's not necessary it should be director identification number. It can be any other authorized number also, because in future they may even link Aadhaar card with DIN number. So Aadhaar itself can be, I don't know, maybe it's there. For CFO and all, they are giving PAN itself, they are making DIN. My CFO has this PAN number has DIN, because it is not necessary you should be a director to become CFO. No? So they are having only the PAN. In section 152 subsection 4, it says declaration to become director. You should declare that you are not disqualified. DI right and all you will be giving. Then 152.5 says you should give consent to become director. Then 152.6a says rotational directors. In case of public company, this section is applicable. This 152.6. Then it says not less than 2/3 of the total number of directors shall be retiring by rotation, and out of that 1/3 should be retired at every AGM. This is what 152.6a says, and 152.6e says these retiring directors are eligible for reappointment in the AGM. In case if the director's reappointment has not taken up in the AGM, or there is a problem, then they can be automatically deemed to become reappointed, provided under section 152.7ab. It says like they should not have expressed their unwillingness, they should not have been disqualified or vacated, and any specific resolution need not be necessarily to be passed in this Companies Act, and they should not have appointed earlier under section 162. So this is what it says. Then 153 says to apply DIN. So we should apply for DIN number with central government under this section 153. Then central government will be means how you will be applying. DIR 3 form has to be filed for application. You should give photographs, address proof, ID proof, and it should be certified by a company secretary or a chartered accountant. or a cost accountant, it should be filed DIR 3 form, and you should give declaration in DIR 4 form. Then only they will give you this DIR, means like DIN. And under section 154, central government will be allotting you the DIN. Within 30 days they will be allotting you. Then 155 says you can have only one DIN. Then 156 says you should intimate this DIN number to the company. 157 says one DIN number has been obtained from the director. It should be intimated to ROC. DIR 12 form is there, so we should intimate to ROC under 157. So the company has to intimate to ROC. Then 158 says whenever the director is signing on behalf of the company as a director, he should sign along with this DIN number, otherwise he will be penalized. So whenever certificate he is signing, no, he should sign, because like how our auditors are mentioning their membership number, like that director should mention his DIN number. Then 159 says they will be penalized for violating DIN provisions. Then 160 candidature, how a person can nominate himself. He can at least 14 days before he should give a special notice that is nominating himself, along with a deposit of rupees 1 lakh rupees. This deposit is exempted for a private limited company or directors who is nominated by the nomination remuneration committee. Then if they are obtaining more than 50% vote, that is if they got appointed, then their deposit will be refunded. If they are not getting appointed but they are obtaining more than 25% vote, then also their deposit should be refunded. If they are getting less than 25% vote, then the directors may take decision. The board of directors can take decision whether they have to forfeit the deposit or they can give back the amount. Then section 161, this is having 4 subsection. 161, 1 is additional director, 2 is alternate director, 3 is nominee director, and 4 is casual vacancy director. Once additional director is appointed, he will be generally appointed in board meeting only. The general meeting has no right to appoint him. Additional director should be appointed in board meeting. He will be holding the office from the conclusion of that board meeting till the commencement of the AGM. Then 2 people cannot be appointed as additional director. One who's failed to get himself regularized in the AGM, and 2 the person who got removed by the shareholders under section 169. Then so it's like the tenure is the AGM date or the last date on which the AGM should have been held, whichever is earlier. So that you should write. Then 161(2) is alternate director. In case a person goes abroad and is not expected to return within a period of 3 months, then the board of directors can appoint alternate director. So only in board resolution they can appoint alternate director. Then but the thing is, even if the board resolution is not taking place, in general meeting also they can appoint an alternate director. But general meeting appointment is not there for additional director, but it is there for alternate director. Then a person cannot act as director himself plus alternate director. So one person can be either director or he can be alternate director. And so previously it is like director can be alternate director, but he cannot be alternate director for 2 directors. This is what there previously. But now after the amendment, director cannot be alternate director. So one person cannot have 2 votes. Then what is his tenure? Till the person, the original director, returns back to India, or till his tenure, whichever is earlier. If the original director got reappointed, it is not necessary that alternate director should also get the reappointment. So you should go for the, again you should stand in the election to get his appointment. Then section 161(3), nominee director. Nominee director will be appointed in case the shareholding is held by central government or state government or financial institution, or because of the loan agreement they can appoint. This director will be holding for a period of 3 years, non-rotational, non-removal. Then generally disqualification will not be attracted for this nominee director under section 164. Disqualification is not attracted for this person. Then 161(4) is casual vacancy director. In case a person got appointed in the general meeting ordinary resolution, if he got removed, or if he got resigned, or if he is disqualified, then the casual vacancy is getting created. So the board of directors can appoint some other director in his place as a casual vacancy director, but the only thing is that original person should have been appointed in the general meeting. So a person who got appointed as additional director, you cannot appoint casual vacancy director for the additional director. Previously the section is applicable to only public company, now it is applicable to even private limited company also. Then, so sir, if a casual vacancy director is appointed, he got vacated, what to do? There is no casual vacancy director for a casual vacancy director because the casual vacancy director is appointed by the board and not in the general meeting. So you should go for 161(1), that is additional director, to refill this space. Then 162 N block, that is appointing, every director should be appointed individually. If you want to appoint more than a single person as a director for more than single person as a director in a single resolution, then you should follow N block resolution. Then so it should be voted unanimously. Unanimously means not even a single vote should cast against. So people think that unanimous resolution will be there even if they abstain from voting. See, everyone should vote in favor. It's not like abstain from voting also. Whoever vote in favor, and people should not be even abstain from voting. Everyone who is present in the meeting should vote. That's called unanimous resolution. So there may be a question like more than 60% of the people are accepted and there is no vote cast against, but 40% of the people are silent. 40% of the people, if they are silent, is they are abstained from voting. It's not unanimous resolution. It's just a normal resolution. Then section 163, proportional representation director. So in case article provides, you can go for proportional representation director. Then what are the two types of proportional representation? Single transferable load proportional representation and cumulative voting proportional representation. See, there may be a question, article didn't provide, can we appoint alternate director? You should write like we have to amend the articles and they have to appoint alternate director, kind of. So whenever there is no provision in the articles, then general meeting, they can amend the articles of association, they can appoint this. Then section 164, disqualification. There are so many confusion with 164 and 167. See, there are like 167 vacation of office. It says like once a director is disqualified, he cannot continue in any other company also, etc. See, it's not like that. It is there in Amendment Act only. Amendment Act is not implemented as on date. So please be sure. So just read as of now 164 and 167 without amendment. 164 says that a person who got disqualified in the following reasons, the reason may be like unsound mind, undischarged insolvent, applied for insolvency, petition is pending, convicted for an offence involving moral turpitude or otherwise, and sentenced for imprisonment for a period of not less than 6 months, and the period of 7 years, period of 5 years has not elapsed from the date of expiry of the sentence, and the period of, provided if he is convicted for an offence for a period of 7 years, is disqualified for life. Then a person who is not having din as provided in section 122 subsection 3. See, please understand there is a difference between 164 and 167. 164 is for disqualification. That means my din number have a problem. 167 is vacation. It's not having problem with my din number. For example, in 167 there is a point, if I am not attending all the board meeting in one company, I am vacating the office. So if I am director in 3 companies, in second company and third company, if I am attending all the board meeting, in the first company I am not attending all the board meeting, I have to vacate from the first company alone. So my DIN number does not have any problem. I don't have any disqualification. So 164 talks about disqualification and 167 talks about vacation. I have to move out of that company. And 164 188, that is 164 one of the disqualification is section 188. Violation of section 188 is also a disqualification. Then then we will go to 164 subsection 2a. If a person has not filed annual accounts or annual returns for a period of 3 years. 164 2b says if I have not repaid the deposits, debentures or interest on that, and declared dividend has not been paid within the due date, then 5 years I cannot be reappointed in any company. 164 subsection 3 for a private limited companies I can have additional disqualification, and 164 subsection 3 as a proviso. The proviso says in case a person who got disqualified because of conviction, he can go for an appeal, and till the appeal is disposed of, he will not be disqualified. So the appeal has to be filed within a period of 30 days, and if the appeal is filed till the appeal is disposed of, if the appeal is disposed of against him, next 7 days he will not be disqualified. So that are the points. Then 165 number of directorship a person can hold. A person can hold maximum of 20 directorship and not exceeding 10 public company. Then what are the things excluded from this? Person who is holding directorship in section 8 company, a person who's director in a body corporate of foreign, then these are the things excluded from this. Then 165 also have like the members of the company who, when they appoint, they can restrict the number of company in which he should be a director. They can even restrict that. Then 166 duties of director. A person should not delegate his duty. He should not assign, the director should not assign his duties to other directors. You should always act in good faith for the welfare of the company, society, employees. Then 167 says vacation of office. A person can vacate the office on following grounds. Should have been vacated the office following grounds. One, he has convicted, means he has disqualified under section 164. He has not attended all the board meetings in last 12 months. He has violated 184. He has not disclosed his interest, or after disclosure he is participating in the interested transaction. Then court or tribunal ask him to vacate. If he has convicted for a period of 6 months, even if he is filing an appeal, then he should vacate the office and then only he should go for an appeal. Then if all the director vacates the office, then who will become director? No, that is the point here. Central government, means like board of director, general meeting, they have to appoint a director. If general meeting is not appointing the director, then central government will be appoint director for this company. Then 168 resignation, how a director will resign. The director has to resign by giving a resignation letter to board of directors. And now DIR 11 has become optional. Previously DIR 11 is mandatory. Resignation cannot be rejected. Resignation has to be accepted. So once the board of director accept the resignation, it should be filed with ROC in the DIR 12 form. The director in his resignation letter has two options. Either he can mention a future date, or if he is not mentioning a future date, then immediate effect he will be resigning. Then this is 168. 168. The director will be, even after his resignation, he will still be liable for the past activities which he has done when he is a director. Then 170. 169. Okay, 169. 169 is removal. If shareholders want to remove a person, they have to give a special notice to the company. Then the company has to circulate to all the shareholders, and you should give opportunity of being heard to the director. Then if the director in his representation, if he is abusing the position, then the board of directors can go to NCLT and get it exempted like auditors. But the only thing is, in auditor and director, the difference is the resolution. Here they have to pass ordinary resolution. There they have to pass special resolution. Then so auditors is special resolution, director is ordinary resolution. Then after its removal, you should file DIR 12 with ROC. One person asked me one question: disqualification effect to other companies. That's why I told you you should not study the amendment as of now. Amendment says, see, for example, Mr. A is disqualified under section 161 subsection 2 for non-filing of annual accounts in one company. He is not disqualified in any other company. He is disqualified in this company only. He is not disqualified in any other company because he has done violation in this company. He can continue in other companies. Okay. Technically speaking, this is what right, because I got disqualification because I have not filed annual accounts in this company. So I should vacate from this company, but I need not vacate from other companies where I am director. But the problem is my DIN number getting blocked. So in any future companies, okay, I cannot get appointed because I cannot file my DIR 11. So those companies cannot file their DIR 12. That is the point there. So it's like no other companies we can continue. This is asked in November 17 examination also, I guess. The first question, I think 1A is this question. You can read that. Then where are we? 169, I guess. 169 is over. Then 170 is inspection of registers of KMP. 170 is KMP shareholding. So directors and KMP shareholding they should maintain, and whenever there is a change they should update. Then 171 is registers of KMPs and directors. They should be inspected. Means like shareholder has a right to inspect the register of KMPs and directors. Then if the shareholders are not given access to inspection of registers, then the shareholders can complain to ROC, and ROC will do the inspection, and they will be submitting the report to shareholders. Then section 172 is penalties for violating this chapter. So here we are concluding revision lecture part 2. Very soon, immediately, means like after some time, I will post my revision lecture part 3 for meetings and remuneration. So if you like this video, please like. If you want to forward, please forward to your friends. And thank you so much. Stay tuned. Kindly do revision from your end also, the back questions of our book, etc. RTP PM or my question bank. Thank you so much. Bye bye.